evening. Oh, let me just get this sorted out here. So, apologies. Oh, sound. Hold on. Sorry about that, guys. Apologies for not warning you ahead of time that I was going live, but here I am. And tonight I have an interesting case, piggybacking off of the case that I highlighted last week, and regarding counseling sessions, therapy-induced memories of alleged abuse. So, yeah. Thanks, Jamie, for the confirmation. Okay. So this case actually occurred in British Columbia, and they were convicted in 2012. So the case that I highlighted last week was 1993, if I recall correctly. And it all came out that, you know, the person had flashbacks and repressed memory of childhood abuse and yada, yada, yada. And that conviction was overturned. But nowadays, you rarely ever see the context of therapy-induced memories in the court transcripts, in the court case itself. The Crowns have learned how to present it in a way where it doesn't look like it's been, you know, therapy-induced memories. It's an actual traumatic incident that they just can't remember very clearly with really clear details simply because it was so traumatic. And that the judge should be able to find a conviction regardless of all of that. So here's an example where that happens in 2012 in British Columbia, and the conviction was overturned, and there was a mention of counseling influence in this, but this case is about a father who allegedly molested his daughter. Historical allegation as well. So it happened allegedly years prior to her going to the police. So let's see. This was a panel of 3 judges, as most appeal course cases, as most appeals are. So he was convicted and then filed for an appeal, and this is his hearing. All right. So the summary: RC appealed his conviction of sexual assault in relation to his daughter. The events giving rise to the charges occurred over the span of approximately 1 year between 1999 and the year 2000. Held, appeal allowed, and a new trial ordered. The trial judge found corroboration for the complainant's evidence when in fact there was none. The curative proviso did not apply. All right, so the main issue apparently is corroboration, and the trial judge found corroboration for the complainant's evidence. Now, in my previous video that I just uploaded, what evidence do the police need to lay charges? I kind of break down more what corroboration means in the legal sense and how it's applied in the courts, and then how that trickles down to the police. Well, it's actually the other way around, but so as we know, the courts do not need corroboration in order to convict somebody, but if the judge decides to, as this case was a judge-only case, most of them are, the judge decides to take a piece of evidence or a piece of testimony from another witness in the trial and applies that as corroborating evidence in a mistaken fashion, then that'll throw the whole case, which is pretty much what happened here. So RC was charged with touching his daughter, AB, for a sexual purpose and sexual assault of AB. He was convicted of sexual assault and acquitted of sexual touching. He appeals this conviction and seeks a new trial. That's kind of strange. Convicted of the sexual assault, but not for the touching, okay? So the background of this case. AB was born in 1992. At the time of the trial, she was 20. The events alleged occurred around 1999 or 2000 when AB lived with her father, RC, her mother, DC, her sister, and her 2 older brothers in a suburb of Vancouver. At one point, AB's maternal grandfather lived with the family in the basement of their home, but moved out when AB was approximately 7 years old. The basement was then set up with a TV and a single chair for RC. It was considered a retreat for him. Probably a, what are they called? The man cave, right? Yeah, with a lazy boy. That's nothing wrong with that. AB says that she did not see RC much as a child. She recalled that most of the time she spent with him was watching TV in the downstairs basement area. AB agreed that she had some difficulty remembering specific events related to the charges before the court. She had reconstructed the time frame of the events in question by speaking to her mother. AB testified that on occasion she would go down to the basement area to be alone with RC and watch TV. She said that she would sit on his lap as he sat in his chair. She testified that he would tickle her and then start rubbing her on her breasts and in her vaginal and buttocks area. AB said that tickling would occur and then develop into rubbing over her clothing. AB testified that she was very ticklish and would laugh while being tickled. She testified that her laughter would change to screams when the tickling turned into rubbing. AB further described the alleged touching as follows. Like I said, he would be tickling me and throwing that in at the same time. AB recalled her father had a creepy smile on his face when he was touching her. His creepy smile was not similar to his regular smile. Her father was not drunk. The incidents occurred when no one else was in the TV room, but other family members were in the upstairs part of the house. These incidents occurred during about a third of AB's visits with him in the TV room. After about a year, when she was 8 years old, AB said she felt this touching by her father was wrong and she no longer went downstairs to watch TV with him. The incidents ceased and AB disclosed these incidents to no one as a child. AB testified that there was a time when she stopped thinking about things that had happened between her and RC. She said she started remembering the incidents a few years after her parents split up when she was about 16 years old. She had talked to friends about it, but first told someone in authority when she went for counseling and ticked a box on a form answering yes to the question of whether she had been sexually abused. The counselor reported the matter to the police. They have to. Mandatory reporters. AB testified that she was unable to give the police officer investigating the allegations much detail in her first statement. AB had told the police officer that she could not honestly remember how old she was when these incidents were said to have occurred. She did not specifically remember what RC was doing when she sat on his lap. She did not know exactly how RC had touched her. When asked specifically by the police officer if RC had touched her between her legs, AB said she could not remember. AB told the police officer she could not explain how the appellant had touched her chest. AB gave a second statement to the police in a subsequent interview. When asked by the police officer for details, AB agreed. She responded in her statement as follows: "I still don't really remember that much." AB agreed that when RC moved his hand from one place to another, he would be moving it as though he was tickling or touching her in a tickling fashion. So before I go on, this is just goes to prove that not only does a police officer not need any sort of real corroboration of an event occurring in order to lay charges and a crown to prosecute, but they also don't even need a full, complete, comprehensive, detailed claim. So this case is an example of that. But it's wrong. I mean, I'm not condoning any of this at all. Nobody should be doing this. I don't care who you are. You know, the purpose of me showcasing these acquittals, overturned convictions in these cases is to show, is to counter the myth that false accusations rarely occur. Women, girls, children rarely lie about being raped. It would be, you know, it wouldn't make any sense for them to go make the claim if it wasn't true. And these cases prove that wrong. they prove that not to be a myth. It is not a myth whatsoever, and it's also not a myth that it is a myth, I should say, that courts and police need solid corroborative evidence or undeniable, incontrovertible proof that something occurred, some really convincing evidence that something occurred in order to lay charges or in order to prosecute and in order for a judge to convict. As you can see, this case is a perfect example of how that is, you know, it's an absolute myth to think that that is the case. Weak, flimsy, I can't really remember what happened, but I know it happened, type of cases run through our courts on a regular basis. And it's wrong. It's absolutely wrong. And so I'm highlighting this so that other people like you who agree that this is wrong understand that there's proof out there that this happens. So you have my resource, you know, my YouTube channel to point to if you ever need this information for whatever purpose. So anyway, moving on. So the evidence of the mother of the complainant, DC, also testified that on some occasions she would go down to the basement to do things and would observe RC and AB watching together. DC testified that both AB and her sister screamed quite loudly sometimes. They both had very loud, piercing voices, and they sometimes screamed over something and sometimes over nothing. That's what kids do, of course. So the evidence of RC testified that he was retired at the time of the trial, having worked for a chemical company for a number of years. I guess that's the grandfather. He confirmed that there was a time period in which AB would... Oh, this is the father, sorry, the accused person. He agreed that there would be time period in which AB would join him in the basement area while he was watching TV. He estimated that she was 7 or 8 years old when that occurred. Okay. RC confirmed that AB would come downstairs approximately once a week. He testified that most often AB came downstairs because she was not getting along with her mother or older sister in the upstairs area. He testified that there were times the mother and 2 daughters would argue, so AB would come downstairs looking for comfort or wanting RC to come upstairs and intervene in the arguments. So apparently she had a completely natural affection for him, and, you know, she also used him to play the family against each other. So RC confirmed that when AB came downstairs, she would climb onto his lap. RC confirmed that many times when AB was on his lap, she would either initiate tickling or he would tickle her back. He testified that she was very ticklish under her arms and on her sides. Now, don't we all do that with kids? You know, I mean, I remember that as a kid, being on my grandpa's lap or my dad's lap and getting tickled. I have pictures of it even, right? It's nothing, it's fun. It's all good fun. RC testified that the chair he sat in was made of imitation leather, and when AB squirmed, she would slide off of her chair. RC testified that at the point he would pick her up, grab her, and put her back on his knee, or he would hold her so she could not slide off the chair or onto the standing ashtray. RC absolutely denied that he grabbed AB in her vaginal area. He testified the only time that he could think he touched her in her chest area was when he had his arm around her. Okay, even then, she's 7 or 8 years old. She don't have boobs, so he's not grabbing at anything. So that's just a ridiculous assumption that if he happens to touch her in the chest area, that it's for a sexual purpose. Come on. It's just ridiculous. These people are disgusting. RC testified that he never intentionally touched AB in her pubic or vaginal area and never ever touched AB in her breast area for a sexual purpose. RC testifies as follows. Okay, now when you were tickling her and she was squirming around, could there have been inadvertent touching in the various part of her body that she described? His answer? It's entirely possible, because she was, you know, she would squirm quite a bit. She was, you know, like little. It's almost like a kitten, you know. If I don't know if it makes sense to you, you know, she would just get very hyper. I have read this in another court case. This exact defense when asked, you know, is it possible you might have inadvertently touched her in these sexual zones? Well, yeah. I mean, she's a squirmy kid at that age. They're jumping around all over the place like little monkeys, right? And they're hyper and they're happy and they love you and they're just all over you. And, you know, you might be grabbing them, getting them on your back or on your lap while they're jumping around. Your hands could go anywhere. So it's perfectly reasonable response to say, yes, it's possible. The problem is that the Crown then will take that information and twist it as if, you know, aha, see, you're corroborating her evidence. And the only difference is that I say you do it for sexual purpose and you say you don't, but let the judge decide. So in the trial judge's reasons, the trial judge summarized the evidence, and at paragraph 27, when summarizing R.C.'s evidence, said he completely denied that the sexual assault occurred, and in particular denied doing that intentionally or doing that accidentally or touching her at all. As noted above, R.C. clearly acknowledged that he might have accidentally or inadvertently touched A.B. during the course of the tickling. See, that's an even slimier way of misappropriating his evidence by saying he denied touching her at all, but then in another sentence he said he might have done it accidentally. Aha! There's a contradiction. He's contradicting himself. He's not reliable. He's hiding the fact that he did it for a sexual purpose. I tell ya, that's what that means. So thank goodness this appeal court caught the fact that he obviously did acknowledge that he may have accidentally or inadvertently touched her in those zones during the course of tickling. Really, why is this in court, right? At paragraph 28, the trial judge referred to the evidence of A.B. that she had stopped going downstairs because she did not think the conduct was right. The trial judge then said at paragraph 29, "It is interesting, I suppose, and perhaps corroborative that that was not challenged in any way." Well, interesting. So, because she said she stopped going downstairs because she didn't think the conduct was right, but that one little point wasn't challenged, that is somehow supporting her statement as being truth simply because it wasn't challenged. How scary. The trial judge concluded that R.C.'s evidence did not raise a reasonable doubt. So the trial judge concludes that the accused's evidence did not raise a reasonable doubt as to his innocence. Personally, I believe it should be a question as to whether or not the judge believes without a reasonable doubt that her story is true, that it occurred. The evidence supports that this stuff occurred, not whether or not he's proving himself to be innocent. This is pretty telling, isn't it? She gave no reason for not accepting his evidence other than to say, at paragraph 36, and this is a female judge apparently, that R.C. made some comments a little bit out of the blue and left her with the impression that he was trying very hard to say whatever he could think of to say in order to impress the prosecutor. Yeah, I've heard that before in many other judgments. Whether it's the prosecutor or a judge saying it, but I've heard judges say this a lot, that basically the accused person would say whatever they can because they know that they're facing jail time and a conviction, and of course they'll say whatever they can to avoid it. And the point of your logic reason is what? Oh, that means he's guilty. Jesus, this is such a fine example of how incompetent our legal system is and can be. Not all cases end up like this. There's really great judges, really great decisions, fair prosecutors, and great defense lawyers. But when you get a case like this, and I have an entire list full of them, it's very disheartening to know that there's even a portion of our justice system that functions at this level of incompetence. In reviewing A.B.'s evidence, the trial judge says, In listening to the evidence of AB, while it is true that it does not provide a great deal of detail, it does provide detail. It does provide particular observations that stayed with this girl. The creepy smile is one of them. She speaks only of screaming when she was being inappropriately touched, although she acknowledges squirming lots of the time. Screaming is something corroborated by the mother. I doubt that it is the only time she screamed, but she certainly corroborated that sometimes she was screaming when downstairs. For me, the most telling is that when she decided to stop it, it stopped, and she did not go downstairs anymore to make it stop. The trial judge then said, "It is clear that there is no suggestion of any further inappropriate touching or activity after she stopped going downstairs, and I accept the comments made by counsel on behalf of RC that this was unusual in the context of there not being predatory behavior, that nothing is suggested to have taken place under clothing, and there is no suggestion of ongoing contact of any kind. This leads me to the conclusion that although there may have been some element of sexual gratification, I am left in significant doubt about that. I cannot find a sexual purpose on the basis of a weird look or a creepy smile, and that would really be the only evidence in the context of these facts on which I would find a sexual purpose. For that reason, I find RC not guilty of count 1, but with respect to count 2, I am satisfied that has been proven beyond a reasonable doubt, and I find him guilty on count 2. Okay, so let's back up here. So the judge is finding statements between the girl and the mother, even though the context is different, the fact that they're corroborating her somehow. But nothing is suggested to have taken place. So because she didn't claim that a hand went, down her shirt or under her pants, because that claim wasn't made, somehow that gets him off of the sexual touching. Okay, that's fair enough. But why is he still being accused of sexual assault? The creepy smile doesn't do it. And she is left in significant doubt that there was an element of sexual gratification. But I cannot find a sexual purpose on the basis of a weird or creepy smile, and that would really be the only evidence in the context of these facts on which I would find a sexual purpose. For that reason, I find him not guilty, but I find him guilty on count 2. I'm satisfied that it's been proven beyond... So I guess she doesn't really give a reason. That's so confusing, except she did make these comments up here that the screaming is something that was corroborated, and the fact that she didn't go downstairs anymore and everything stopped after that. That sounds like those are the only 3 points which she picked out of all of this to decide that he had to be guilty of something. Even though juxtapositioned by all of this other stuff that she seemed to be completely unconvinced by. So it's a really weird decision, isn't it? Really careless conviction as well. Very careless. So the issues on the appeal here, the appeal grounds submitted to the appeal court was that the trial judge erred by failing to give any reasons for rejecting the evidence of RC, which obviously she really pretty much did, misapprehending the evidence, failing to give coherent reasons for conviction, and finding corroboration for the complainant's evidence where in fact there was none. So these are all absolutely exactly what happened from what I can see. So the appeal judge goes on to say, in their view, the trial judge erred on all 4 grounds. Wow, that's so rare. Just so you know, if you go back to all my other live streams, usually only 1 ground of appeal out of a handful of grounds of appeal makes it through the court. So in this case, all 4 of them were accepted by the appeal court. That just goes to show how phenomenal and monumental of a mistake this conviction was, and this judge, just wow. All right, so the entire analysis for rejecting RC's evidence is set out above. RC is entitled to know why his evidence was rejected. The trial judge stated that his explanations were to impress the prosecutor. This appears to be the only basis on which she rejected his evidence. The complete analysis for conviction on count 2, sexual assault, is set out above. The trial judge did not analyze the elements of the offense and did not consider the defense of accident and inadvertent touching. Indeed, she misapprehended RC's evidence on this point. In my opinion, however, the error is in relation to relying on evidence as corroborative when it could not be, is so grave that there must be a new trial. Therefore, I propose only to address that aspect of the case in any detail. The trial judge relied on 2 pieces of evidence of the mother, DC, which she found supported the credibility of the evidence of AB. These were the fact that DC heard AB screaming from the basement and the fact that AB at some point stopped going downstairs. In terms of the latter point, the mother never said that AB stopped going downstairs. The trial judge misstated that piece of evidence. Okay. In order for this evidence to assist the trial judge in assessing the credibility of the complainant, it is necessary for it to be more consistent with one version than with another. AB testified that she was very ticklish and that she would laugh and scream at the same time when she was being tickled. DC's evidence with respect to AB's screaming was that AB and her sister would both scream quite loudly and she would not always know why. She did not testify that she heard AB scream when she was in the basement. There is nothing in her testimony that supports AB's version of events. The trial judge erred in law when she relied on it to support AB's testimony. So, as I've spoken in I think the last stream, one of my recent streams, I've talked about how when you're reviewing a case for an appeal, a wrongful conviction for an appeal, this is why you can't trust a judge's judgment, obviously. I have said this before, where you have to read the judge's reasonings and then compare it to the Crown submissions and first see where the evidence clashes there. And then take that and then go compare the Crown submissions to the actual testimony that the complainant and the accused or any other witness gave to see if it's an accurate, the Crown submissions and the judge's understanding is an accurate reflection of what was actually said in testimony. Because oftentimes I find that's not the case. That's how incompetent our system is. Can be, I should say. That's how incompetent it can be. And this is obviously another classic example of where nobody looked back at the transcripts to verify the testimony from anybody before coming to a decision that destroys a man's life and completely ruins a family in the process. Just terrible. So, AB testified that she stopped going to the basement because her father was touching her. The trial judge said that it was not disputed that AB stopped going downstairs and suggested that the failure to dispute the evidence was corroborative of AB's evidence. Mind-blowing. AB was not cross-examined on that fact that she stopped going downstairs. However, RC did testify that there were no acts of intentional sexual touching. He said that there may have been inadvertent touching, a piece of evidence misapprehended by the trial judge, and that he did not want the children visiting him in the basement as this was his retreat. Fair enough. The man cave. In my respectful view, the fact that AB was not challenged on her evidence that she stopped going downstairs because of improper conduct by RC does not make her evidence more credible. There is nothing in the evidence or position of the defense that suggested RC accepted this as truth. The learned trial judge erred when she found the lack of cross-examination on this point corroborative of AB's evidence. In my view, these errors of laws must lead to a new trial. AB's evidence was fraught with difficulty. She had little recollection of events and could only describe things very generally. She reconstructed the time frame in conjunction with her mother in advance of the trial. The trial judge did not actually say she accepted AB's evidence. That is implicit in her conclusion that RC was guilty. Her conclusion that AB's evidence was not only truthful but reliable must be found in the fact that she relied on evidence and lack of cross-examination as corroborative, when it could not amount to corroboration. In my view, it cannot be said that the verdict would necessarily be the same had the errors not occurred. Therefore, I would not apply the curative provision in Section 686 of the Criminal Code. I would allow the appeal, set aside the verdict, and order a new trial. All right, so obviously the correct outcome, but again, not the optimal. They're basically saying that if these judges hadn't made this, if this judge hadn't made these errors, they could still find the man guilty. So, yeah, again, that speaks to the very low standard of quality of evidence that is admissible into a, a court of criminal law, and the low standard of evidence that is admissible or that is acceptable for even laying charges. This case pretty much encapsulates that. So we know, I can tell that another trial didn't happen. The charges were obviously stayed. No acquittal was entered. So, unfortunately, because this is obviously the most ridiculous case, right? All right. Oops. I'm gonna pop the chat open here so I can see what you guys have to say. So I'm opening it up to comments and Q&A now, guys. Okay. All right. So, hey, Fillerator. Oh, link. Yes, I'm going to do that now. Sorry you didn't get to follow along, but put the link. Please forgive me, Fillerator. Okay. And there is the case. I will also add it after I've shut down this live stream. I will also add it to the description area in the video upload. So Fillerator, surely the question should be, did it actually happen, not whether it is possible? Yeah, right? I know. That you really point out one of the major problems here. So in a criminal court, they tell us, we read it in the media, we hear it out of lawyers' mouths, and judges and whatnot. They tell us that the burden of proof is incredibly high. The standard of evidence is incredibly prohibitive to, accidentally convict somebody. But these cases prove that that is not true. So to have a court open, a criminal court, any court, okay, when you have a court open to just determining whether or not the possibility of this incident could have occurred, that constitutes what is known as a preponderance of evidence, right? And that is the standard that is in a civil court. So ultimately, that's where this case should have gone, a civil court. But for whatever reason, it didn't. But see, in the civil court, it's a little different in the civil court than it is in the criminal court, because in civil suits, each side has to go through an equal amount of what they call discovery and depositions. So, there's a lot more intense questioning to get at the truth. And because there's a lot at stake, it's money. Apparently, money is, considered to be more of a higher stake than somebody else's life. Their future prospects of, whether or not they're going to be imprisoned in a very dangerous prison environment, put on the sex offender registry for life, or, even any amount of time. It's a major punishment. It's a major black cloud that hangs over your head. Just having a conviction on your record precludes you from all sorts of jobs and security clearances, and rumors start spreading around, people start shunning you. It just creates so many problems. Whereas in a civil suit, the award is just money. You just agree to settle for some money, a money value. You put a a dollar sign on emotional damages. And now, just because these cases go to criminal courts doesn't mean they don't also play out, you know, at some point in parallel or before or after in a civil court as well, because they can. You can have your case brought to both arenas at any time. And it's disgusting that, you know, this whole question of whether or not it's possible in determining, you know, if I think she's credible in telling me the truth just by my own gut intuition and just, you know, by completely twisting the evidence to fit my bias because she seems like, you know, poor little girl, you know, like, come on, that should not be our standard. But the appeal court confirms that is our standard because they did not call a new trial. They didn't, they didn't enter acquittals, and they called for a new trial. So, you know, they only call for a new trial when they believe that without those mistakes, a conviction can still be had. So that's when they do that. And in most of these cases, if you've been following all of my live streams, they all call for a new trial. Very rarely do I come across one where acquittals were entered, it's done with, over, the Crown can't touch with you, can't mess with you anymore. Although they can appeal it, but it's going to be really hard. Like, the chances of them succeeding in that appeal are very low. The police use the same tactics. Then they go to court and tell the judge you contradicted yourself. Yep, I know. It's terrible tactics. Logic MK, there is no possible way to make any form of a statement without the police or the Crown twisting or warping anything anyone says. Yes. And that's why I would never want to have anything to do with the courts. I don't care what type of claim I'm making. I've never filed a report. I did attempt to in one case a little while back where I was defrauded by somebody, and the cops basically said, you know, sounds like a civil case. Okay, well, which means that I have to pay for it, and you know, that's reasonable, I suppose, but then, you know, I run the risk of, if I were to lose the case for some reason, I would also have to pay the other side's expense. Plus I had there was a lot at stake in my particular situation, and I had to consider the thought of it all going public. And in a civil suit, you know, your stuff is more likely to go public. I can't imagine getting a publication ban on that kind of thing. Whereas if you make a criminal case out of it, you might have a better chance of getting a publication ban on something. So I didn't go forward with it because I just, you know, knowing what I know about the system, the thought of getting involved in it just turns me right off. It you know, my life has already been drastically damaged by my partner's case and the fallout from that and everything. Why would I want to put myself through more hell? So I had to accept being defrauded. And, you know, by the way, for those who are listening, it was a private investigator who defrauded me. That I was given a referral to them by a very well-known nonprofit organization that is funded by our government to supposedly help people who've been wrongly convicted. I won't say any more about that, but nonetheless, they referred me to somebody who defrauded me of thousands of dollars. And because of that high-profile attachment to the referral, that is also something that scared me away from pursuing any, you know, recuperating any of it back in any way, shape, or form. So anyway, you know, that's an aside, but that's just going to show, that just goes to show how disgusted I am about the whole system and how it operates. And it doesn't matter which side of the fence you're on. And it's just it's so disgusting because, you know, whenever somebody has an agenda or a bias, you know, you will have your words and everything twisted around against you. And I've seen it happen in such slimy, disgusting ways that it literally makes me sick to my stomach. And I have already spent enough years being sick to my stomach learning, you know, how this system runs. So I really don't need any more of it, right? So, Simon Ford, are you allowed to name the trial judge? Why did the police go forward with no evidence? I can name the judge from this particular judgment if they are named. So, in this judgment, let me see. An order of the Provincial Court, British Columbia, dated April 12th. No, they didn't name the judge in this case. I wouldn't even know how to get that information. I'd have to contact a lawyer. But I find that's common in these judgments. The judges from the trials are not named for their protection. A lot of secrecy going on. But if the judge's name was in this decision, yeah, I could name them. Roscoe, I suggest bias by the judge, in-group preference. Also, you should have a separate look at the pressure magistrates and judges are under to convict, particularly in matters of alleged sexual violence. I wouldn't know. I wouldn't know anything about that. The only thing I can say about that is that I should be more concerned about the pressure that the judges should be to uphold the rule of law and the fundamental principles of justice, and not to find convictions on weak evidence, because that is a very perilous situation. You are putting most likely a factually innocent person in, and that is what society should be worried about. I'm not gonna, you know, no, that's the only thing that I worry about when it comes to the judges. Logic MK, you can't justifiably convict because someone feels like something might have happened to them. Therefore, the accused needs to do some time to act as a band-aid for the accuser. Yeah. A lot of feels in our courts, you know. Obviously, there's more context to the relationship of this family in this case that I just read out, but we don't know what it is because apparently it's not relevant to the actual issue at hand, which is the sexual touching. So I'm going to assume that there's context around here that we're not being told, and I'm just going to take a stab in the dark and say it's something along the lines of the little girl grew up and obviously she had a lot of affection for her dad. And then maybe as she got older, things didn't quite go her way. She didn't get her way anymore like she used to. She used to be able to go to her dad when she was a kid for protection and comfort when the rest of her family was fighting. And she would use him and pit him against, you know, try to anyway, get him to, you know, pit him against the rest of the family. So I'm going to assume at some point in her older years, she got into some kind of trouble or something, and her dad just wasn't giving her what she was used to. And that was, you know, all the comforts in the world whenever things weren't going her way. Typical. It's not unusual. Very typical. But, of course, that won't be discussed in the transcript here. So, it doesn't help fix anything but the pockets of the legal system. Yeah. Jamie, is the Crown required to play the entire video statement by the complainant, or can they cherry pick or edit the statement to their liking to support their side? I believe they have to play the whole statement. But I don't think they do in all cases. I think they can just cherry pick. But, you know, that's a good question. I'm not 100% sure what the legal requirement is there, if the entire statement, video statement needs to be played. But as long as there's a transcript of the entire video statement, the defense also will just cherry pick stuff to pressure her on or cross-examine them on. So it's really, you know, both sides are just cherry picking, right? To get the job done. If so, having introduced such evidence, is the whole statement now fair game for the defense to bring into question? Yes. So I just pretty much answered that. Yeah. the entire statement. I know of a case, for example, I'm trying to think back, where it clearly states in the transcripts, the trial transcript, that she was questioned on some points that she made, contradictions that she made in her police report, the preliminary inquiry, and the trial. So, like, in each phase, she had made wildly different claims, and everything just kept changing and progressing as she got to trial. So she was confronted with that. And then when it came down to the actual positioning, you know, the physical possibility, plausibility, and her recall of the actual alleged sexual act itself, the video, only that portion of the police video was played at trial, to have her confront, you know, what she had initially said to the police, and get her to, you know, sort of backpedal on, well, I guess that's, I must have been wrong. It must have been the other leg was over here and this leg was over that, whatever. So, yeah, so basically, everything is fair game. That everything that the Crown brings up is fair game. Everything that was recorded in a previous trial proceeding is fair game. Whether the Crown brings it up in the next one or not doesn't matter. The defense can still bring that up because they had already gone on record under oath, so that can still be resurrected in the next proceeding. Yeah, so I hope that answers your question. It can be kind of complicated, but yeah. So Simon, in Canada, do you have a peer review for judges? Can they be judged incompetent and be removed? Yeah, that's, hi Sean Doherty. Yeah, technically yes, but what that process looks like, I mean, I've seen it in various different ways. So we have what's known as the Canadian Judicial Council, and they're, you know, deemed an independent body and a self-governed independent body, because they have to be independent, seen as independent from the prosecutor's office, as well as the government and the Minister of Justice. They're not governed by anybody else, just themselves. Now, when you want to discipline or peer review a judge, I think it happens in cases where people create an outcry. It typically starts in a university somewhere, in a law school class. Some, you know, legal professor is outraged by a recent case, and she is, you know, getting her students all riled up about it. And then the next thing you know, there's a chain letter and a petition being signed by other legal students across the country to demand that a judge in particular be condemned, reviewed, and removed from the bench. And that's exactly what happened to Judge Robin Camp. So, Simon, if you're interested in digging back into my archives, my video archives, look up the re-education of Judge Robin Camp. And that's a really good depiction of what can happen to a judge when somebody's not happy with them. It doesn't matter for what reason, but my video is a good example of that. Yeah, Robin Camp. Did I say something else? Judge Robin Camp. He's a great story. It's so sad what happened to him. It's a terrible situation. But, you know, maybe, I don't know. Logic MK, I've heard of some crazy stuff about how little they do to discipline judges unless they get attacked by the SJWs. SJWs, yeah. That's pretty much what I just explained. Outside of that, I really don't know what a process would look like. Again, Canadian Judicial Council, go to their website, I guess, and look it up, but it's a pretty, you know, tightly locked down organization that nobody has access to. So, you know, the public in general, like, there's no transparency there whatsoever to the public because of that independence that they really hold dear, which should be the case, I suppose. But as far as, I mean, I can tell you there's many cases that I read, And I'm thinking to myself, how do we get rid of that judge? Is that judge still operating? That judge should not be sitting on the bench and deciding cases. It's scary. How many innocent people are going to jail because of this judge? But you would think that each time a judgment of theirs is overturned, that would add up. That would, add up in points against them. And that, they would be disciplined perhaps based on how many of their own judgments get overturned. That's something I've always wondered, and I have no idea how that works. None whatsoever. Jamie, off topic here. If you're charged with sexual assault before C-51 became law, do you get tried under the law as of the date you're accused or the law of the day? In that particular case, it would be the law of the day. Because of the particular provision. Now, the provision that got passed in C-51 is different than as if a new type of criminal offense was introduced. So, for example, if Bill C-51 passed a new type of criminal offense, had a whole new section number, like right now sexual assaults are 271, 2 and 3 levels. Let's say they created, sexual assault 700, some kind of new crime, right? Some specific type of crime. If you were to be charged now under that new crime, if the alleged crime allegedly occurred before that crime got on the books, then you cannot be charged under that new crime. You would be charged under whatever crime was on the books in that day the alleged crime occurred. That's correct. However, what actually was this particular provision in Bill C-51 that I believe you're referring to are the basically the rules of evidence. And it's that applies to the day it became law. So it doesn't matter, when you were tried. It doesn't matter when you were charged. It doesn't matter how far along you are if you're mid-trial and this law was passed, you would have, suddenly everything would blow up your trial. You'd probably have to start over again, or I don't know. Like, I can't imagine how that could have derailed any actual trials when that provision was put in place. 278. 278 it's the records production clause, if you will, or provision of basically, what a defendant is allowed to, or how a defendant, or I wouldn't even say a defendant, but what documented history of the complainant is admissible as evidence and what is not admissible. So automatically, pretty much nothing is automatically admissible under 278, including digital communications that the defendant may already have in his own possession. So now it's an automatic now where he has to have a hearing to have that stuff admitted by a judge, and in that process the Crown gets to see what evidence he has under his sleeve, as well as the accused person. I mean the complainant. The complainant will now know the defense's angle. So yeah, there's no time bearing on that. Logic MK. One judge was going through a divorce and for months decided to give every person who came across his bench 3 or 6 months without even listening to anything, even if the folks were innocent. Wow. He got 30 days off, then more vacation time. Wow, that's a nice guy. So the guy's in a pissy mood because he's going through a divorce and just decides to instead of read everybody and evaluate because his mind is somewhere else, just give everybody 3 or 6 months. That ought to teach him a lesson. That's nice. Wow. All right, guys. So that's our case study for the day. Or for the week. I hope you enjoyed that. And if you have any other questions, and also thank you to all of the wonderful donations that have been coming in. again appreciate that so much, and it helps me sustain this channel and keep on going, and it shows that there's appreciation for the content that I am putting out. And believe me, I have so much more content to put out, so I will just keep pushing it out until there's nothing left to do, or until the laws change and, you know, all of my stuff suddenly becomes irrelevant. Wouldn't that be nice? Yeah, you know. But until then, I'll keep at it, and thanks all for watching. And if you're new, please subscribe. And let's see, is this little subscribe ticker thingy working? Let's see. There you go. Yeah, so subscribe and hit the notification button, and yeah, so that you get notifications when I upload or when I'm going live. And check out my website, socialtheorywatch.org, and there's all kinds of stuff there. So yeah, everybody have a great evening, and thanks again for joining in. Good night.